Okay. All right. Hi. So again, my name is Cathy. I'm from Brooklyn Legal Services, and I'm going to talk a little bit about the history of the harassment laws to get us started. And then we will go into a Q&A after, and then a couple of the other sessions. So if you have questions, please feel free to put them into the chat as I speak. Okay, so the first thing to kind of know about when it comes to harassment is what the Housing Maintenance Code is. So that's the first little bubble. Yes, thank you. So this is the PDF that you can click on or go to in order to get to the full Housing Maintenance Code, which is pretty lengthy. But some main takeaways is that it describes and defines different terms, like who is a tenant, who is an owner, what type of apartments there are, what type of class they are. So for example, an apartment that is a class A unit means that it is like a legal apartment. In other words, it has 2 forms of egress. There's the restroom inside, a kitchen, things like that. It also has rules around access. So it will say when a landlord can request access to your home, under what conditions, and when they can come in without notice, I guess, as well if there are emergency conditions. It also outlines what types of violations HPD can issue, which is the city agency in charge of enforcing the Housing Maintenance Code. So that can include from immediately dangerous conditions like mold or lack of essential services, such as no gas, no heat, no hot water, to what is considered a Class A violation, which can be something a little bit milder, like if there are cracks in the public stairway that are not a tripping hazard, right? Just ordinary cracks in the ceramic or something like that. I also want to just kind of touch on the Civil Court Act, which is what governs or sort of outlines why the courts must have an HP part, which is the part in the housing court that harassment cases can be heard in. We're also going to talk about some of the other ways that you can bring harassment claims, but just speaking for the HP part. And the Civil Court Act also gives the judges the power to sort of find, sorry, I just saw something, injunctions against harassment, meaning if they do make a finding that your landlord has harassed you, they can give you the type of relief that would mean not only does it stop now, but it has to stop in the future. And it sort of outlines a lot of things around remedies that people can be entitled to. So penalties and fines and things of that nature. So, sorry, Greg, you can flip to the next one. Cool. So before 2007, harassment was kind of tough for a lot of tenants, specifically if you were not rent stabilized or rent controlled. So any unregulated tenants, meaning if you lived in a private home or if you lived in a unit that had been deregulated for some particular reason, there was no way to bring a harassment claim against your landlord. So that meant that you had no cause of action, which is what the C/A is sort of shorthand for. And you didn't have a defense to raise as harassment, meaning you couldn't say that you were being harassed by your landlord if you were taken to court in an eviction case. And you couldn't countersue the landlord if you were being taken to court on an eviction case, claiming that you had been harassed either through that case or through some other reason. The only way that people could raise a harassment claim was through DHCR, which is the state agency that governs all regulated housing in New York State. There were also a series of lots and lots of cases that went through various appeals courts because landlords fought so hard against the idea of a tenant being able to sue them for harassment. Okay, so then in 2007 is when 2 bills were proposed to the New York City Council. So first, just to flag the Erstat law, which is a law that came out of the 1970s that prohibits the city from making any stronger rent stabilized laws than what the state already allows for. So again, DHCR governs the Rent Stabilization Code, which is the state sort of group of laws that governs all regulated housing. And the city can't do anything stronger than that, but the remedy that we all have is to go through the city council that can then codify things into the administrative code, which is also the Housing Maintenance Code. So the 2 bills that came up first, one was 62707, which meant that a tenant could have a private cause of action against the landlord for harassment. And then the second bill that was proposed was actually for the landlords to be able to sue against tenants harassing them, which is pretty awful. Luckily, that did not pass. So we can go further. Okay, Local Law 7, which many of us know and love. So this did amend the Housing Maintenance Code. It was the first law that did pass. So it codified a private cause of action into the Housing Maintenance Code so that tenants could bring harassment claims against their landlords. There was still a huge push by landlords to fight against this, stating that it was unconstitutional. They fought that for a little over 2 years until finally the appeals court said, you know what, this is totally constitutional. It is fine for tenants to be able to sue their landlords for this. And then on the side of the presentation, that just sort of has the requirements that you need to prove or to establish before you can bring a harassment claim. So you need to establish that there's, oh God, it's fine. You all can look at this later too. It's lengthy, but I'm trying to fly through it. Go ahead, you're good. Okay, 2015 amendments. So quite a few years later was when we were finally able to amend some of the laws around harassment. And so for the first time in a long time, the council started paying attention to buyout offers as another form of harassment that regulated tenants specifically were experiencing from their landlords. So I guess as many of us know, like a lot of times landlords will decrease essential services, they'll let buildings get really, really awful, and then they'll offer people a couple of $1,000s to move out, right? Because they've had to live under these horrible conditions for so long that taking the money and moving seems like a great idea, and then landlords will flip it and charge a lot of money and take it out of stabilization. So the city council was finally paying attention to that, and they changed the law so it does add the buyout sort of as an option or an act for harassment. And now, as a friendly reminder, there is the intent requirement. So in all harassment cases, while it was in the posting. Oh, sorry, I heard somebody. Sorry. I don't know if you can put your phone on mute. Okay, hello, I'm back. Sorry, it's very weird to do this through Zoom. So the intent requirement is where the landlord has, like the tenant at one point did have to prove that the landlord intended to cause a tenant to vacate in making the buyout offer, and that offer had to be paired with something else. So it had to be paired with some sort of threat, obscene language, or some other sort of thing that took it a little bit further. But as part of the new amendment, the landlord also had an obligation to affirmatively tell the tenant that they had the right to refuse the buyout offer, that they could stay, and that they could ask for legal help. And the landlord was only permitted to give a buyout offer once every 6 months. So if the tenant says no, the landlord can't ask anything else for another 6 months. Okay, 2017 and 2018, there were a few more amendments to the harassment law. It added a series of more acts that qualify. It also added some fines and penalties that a landlord has to pay if they are found to be harassing the tenant. And it shifted the burden of proof a bit. So before, the tenant had to prove that the landlord made any type of acts or any types of threats or actions against a tenant, and the tenant formally had to prove that the landlord did those things with the intent to harass somebody. And now with these new amendments, there is a rebuttable presumption that is created, which means the landlord has to prove that if a tenant complains of these acts, that the landlord had some other reason for doing them that was not harassment, which is kind of awesome because most of the time, if a landlord is doing some of these really shady things, for them to pretend like it's for any reason other than harassment is pretty weak. So that's a pretty nice win. And then it also created mandatory damages awards that can go to tenants, including attorney's fees and costs. So all the better there. All right. Most recently, last summer, with the passing of the HSTPA, which is an amazing and historic win, there are some additions within that law that, while not titled harassment, they did codify some parts of the acts that were formerly and currently in the harassment statute that are now forbidden by the HSTPA, right? So retaliation, formally, if a landlord did any acts to retaliate against a tenant for making complaints to a city or state agency, complaining about repairs or some other form of needing help to their apartment, and then brought a housing case within 6 months of that complaint, that was grounds for harassment or retaliation. Now, the tenant can make a complaint to not just those agencies, but also to a landlord. And anytime a landlord brings a case within a year of those complaints, it creates the rebuttable presumption of retaliation. There's also now parts of the law that require landlords to give reason if they're not going to renew an unregulated person's lease, or if they want to raise the rent over 5%. There are also parts of the law that state that there's now a misdemeanor for harassment, which Greg will talk about later. And the last part. So right now, on the 22nd, there was the introduction of the COVID-19 relief package, which is asking to once again redefine or add to the definition of harassment in the Housing Maintenance Code to include any threats that a landlord has made against a tenant based on your status as a COVID-19 impacted person, your status as an essential employee, or any receipt of rent concession or forbearance. So I'm not quite sure exactly when they will vote on this. Maybe someone else will have a better date in mind, but it is pretty nice that they're considering these things for now. So hopefully it will get passed. I think that's it for me. I don't know if folks have questions.
There was one question, I think Greg might answer this later, or you might know this, but how to contact the DA / use the criminal code specifically.
Yeah, that'll be have its whole own section.
Great.
And for folks interested, on the shared drive that with the link that we sent you all earlier, it does have a little bit more explanation and meatiness to some of this stuff. It was mostly just to give us some context for the rest of the presentation. Thanks.
We're now going to go into harassment generally, and some examples of harassment and how to track it as a tenant to prove in court that the landlord has been harassing you. So some examples of harassment are lack of repairs in an apartment, no response from the landlord or super when there are conditions that need a repair, repairs made by the landlord that only worsen the condition, unnecessary construction in the apartment or around the apartment, the landlord or the super threatening tenants with eviction or other retaliation for asserting their rights, the landlord or the super making implied or express threats of force or violence, lack or discontinuance of essential services such as heat, hot water, gas, etc., for an extended period of time, no response from the landlord when there are conditions in need of repair, lack or discontinuance of essential services repeatedly in the building. Sorry, just waiting for the next slide. Bringing cases that have no merit, so bringing frivolous cases against tenants, taking a tenant's property, taking out an apartment door, changing a lock without giving a tenant a key, buyout offers, as Cathy was talking about, after a tenant expressly told the landlord they do not want to be bought out, and any other act that interferes with the tenant's peace or use of the apartment and causes the tenant to leave the apartment or waive their tenant's rights can't be seen as harassment. So there's a lot of things that can't be claimed as harassment when you're bringing a harassment case, a harassment HP. And it is important for tenants to track their instances of harassment. And there's like a number of ways for tenants to do that. Just waiting for the next slide. So definitely taking photos or videos of conditions in the apartment is important to take videos of conditions like lack of heat or hot water, because those aren't things you can obviously take a picture of, but you can take a video with a thermometer checking water temperature, the temperature of the apartment to prove that there was a lack of heat of hot water, or if there was a condition that happened during it and you couldn't take a photo of. It's hard to take a photo of. Videos are really helpful to prove harassment. Videos of interactions with the landlord or their super, if there's any threatening language or just threats of any kind from the landlord or the super. Voice recordings of interactions, voice recordings of phone conversations with the landlord. Sometimes it's hard to prove what was said over the phone, obviously, so it's good to kind of record what is going on with the landlord. Emails with the landlord or the super regarding repairs or any other conditions or any other interactions, voicemails, the log of phone calls to the super if you're calling, of the landlord to the landlord or the super if you're calling the landlord and the super multiple times to get something done, it's not happening. It's a good way to show that there's no response. Log, a lot of people do logs, excuse me, log of conditions such as lack of heat or hot water, so you can get like a piece of paper and just write down every time there was lack of adequate heat or hot water and the times, and if you have a thermometer, the temperature. Keeping correspondence with the landlord with proof of mailing, so if anything that you've sent to the landlord regarding any conditions or any interactions or any issues in your apartment, it's good to keep track of that. It's good to have these things in writing as proof. Log, I already have this. You can also file a complaint with HPD via 311 or online regarding conditions in your apartment. And inspectors from the city will come in, inspect the apartment, and they can cite violations for things in the apartments, and those violations can be used as definitive proof of the condition in your apartment if you go to trial or you're in court. And then there's also this tool, Just Fix NYC. It's a website, it's also an app. So they have a bunch of tools to track conditions and harassment in apartments, and they're really handy. They can actually help tenants write letters to their landlords. There's within the app itself. So those are just ways to keep track of what's going on and have proof for when you file these cases in court. And that's it for me, if there's any questions.
So there were a couple. The first is, what about if your neighbor is doing the harassment?
We get these kinds of questions a lot, unfortunately. So one, obviously, like, we don't, you can, there's like mediation you can do with neighbors. If there's issues, actually 311 can help you conduct mediation with neighbors. If there's harassment, you can call them, let them know what's going on, and they can conduct mediations. Depending on what they're doing, you can talk to your landlord if they're, letting like music blast really loud after a certain time, or they're doing something, they're coming to your door and things like that. You can actually, tell the landlord, let them know what's going on, because the landlord also has like the responsibility to make sure that tenants aren't creating like nuisances in a building or in an apartment that would harass another tenant. Unfortunately, depending on the level of harassment, you can call the police, file a police report to kind of show what's going on with the neighbor if these things do happen.
How about when the neighbor is like allied to the landlord to harass the own tenant of the apartment, like putting in combination to harass the tenant?
Okay, so let me I know Greg was going to add something to what I said, and then I can answer that question.
Yeah, actually, and that follow-up question kind of melds with this. One thing that is important to know is that if it's just your neighbor who you feel is harassing you or harassing a tenant you're working with, there have been recent decisions that say that this law that Cathy talked about, the Housing Maintenance Code and its definition of harassment, doesn't apply to interactions between two tenants. It's just about the landlord and the landlord's employees or agents. and the tenants.
So there's
Great.
one more question, which is a little bit evidence-based. Oh wait, two more. So the first one is, how do you get stuff like voice recordings or videos in front of a judge at housing court when you're filing an HP?
So when you're filing an HP and you get to a point where, you know, you're trying to prove your case, when you get to trial, you can introduce these things as evidence of harassment, of, you know, of your landlord harassing you. So there's rules of evidence that you have to use to follow in court, but you can introduce them and say, you know, to the court that these are, this is the evidence that you have to prove your case in the harassment.
Another question is, how do you preserve these documented logs, recordings, and pictures to avoid evidentiary issues when attempting to introduce them in court?
That's a good question. I think, you know, there are a lot of rules of evidence. So if it's just like things you're, you know, doing on your behalf to kind of track the harassment in the pictures, you just have to introduce them as you would any piece of evidence, right? You have to like lay the foundation. Say if you're the one that logged it or your client, like this is your, you know, your client's work, this is why they logged it, this is, you know, what was happening at the time. The same with pictures, if they took the pictures, if they have knowledge of the condition or the video of the act or what have you. So it's kind of the same thing. It's like you kind of just have to follow the rules of evidence, and usually they can come in if there are no obvious, like, if, you know, if they're not hearsay, even if there are exceptions. So you kind of just follow the same kinds of rules.
So there's another question similarly, but maybe this is a good time to break out into breakout rooms for HP cases generally, where hopefully we can address some of these questions a little bit more specifically. If you want to break us into groups, Jessica.
Sorry, 1 second before we break out, I wanted to add one thing that this comes up a lot, is the question of whether you're allowed to record your landlord or your super. In New York State, it's called a one-party consent state, which means you can audio record or video record like with your phone hidden in your pocket. Mm-hmm. If you're part of that conversation, it's completely legal for you to be doing that. Yeah. So if the super's coming to your door and screaming in your face and you have your phone in your pocket and you record it, it's legal and you can use it as evidence. Right. Also, if your landlord's calling you and harassing you and you audio record that phone call, like if you put it on speakerphone and record it, or you use a recording app, you can also do that. So if you open up the Google Drive that we shared at the beginning of the presentation, there are instructions on how to download a free app on an iPhone or Android for recording phone calls using a smartphone. And it's pretty easy to use, and it's a great way to trap crappy people who don't think that they're being recorded.
Okay, and so there's two more questions which I can raise here, and then we can talk about in the breakout rooms as well, maybe?
Sure.
The first, which is a great question, all of them are great questions, but this one comes up quite a bit. So it's when a tenant who is not an employee of the landlord or the super, but has a close relationship with them, conducts harassment on behalf of the landlord or super, can that tenant be accused of being an unpaid agent and use the landlord or super laws?
Well, that's a good question about like being an unpaid agent kind of, but it is, you can say it is like a way the landlord is using, you know, a method the landlord is using to harass you, right? Like along with everything else, they're also using other tenants to kind of push you out of the apartment. So you don't have to say they're an agent or anything like that. You can say, you know, another way the landlord is harassing me is like they're getting other tenants to knock on my door and things like that to harass me. So it's like part G of the harassment statute have like a catch-all where it's like anything else that is intended to, you know, push a tenant out of the apartment or have them waive their rights. That's one of those things, right, where it's intended to push somebody out, even though the tenant isn't, you know, doesn't work for the landlord, but they're being used to harass another tenant and push them out.
Yes. And I think just adding to that a little bit, which is mostly just saying exactly the same thing that both Greg and Rita said earlier, which is, I think, for those of us that are on the tenant side, we really want to be clear that who we are bringing these harassment cases against are the landlords. And I think for multiple reasons, it's possible that a landlord will use a tenant against another tenant, either by intimidation or offering deals to one tenant to partake in this bigger pattern or act of harassment against another tenant, which is horrible, but often does happen. And so when bringing these claims, we're still just naming the landlord, right, or the owner. We don't want to name other tenants because while things are tricky and everyone has their own situation, we do try to be really careful to never get involved in a tenant versus tenant action or to sort of add fuel to the fire that the landlord has started in pinning tenants against each other, because they do that and they do it well. So one more question, maybe before breaking out into groups, which is if an upstairs neighbor is flooding the tenant underneath and destroying their property, the landlord keeps fixing it, but he doesn't want to do anything. What options does that tenant have?
So if it's the upstairs neighbor that's flooding the tenant, the landlord actually has a responsibility to sue the tenant in court if they're creating what is called a nuisance. So they're making it so life for other tenants is impossible or very difficult. So if another tenant is doing that, the landlord has the responsibility to sue the tenant for creating that. But also, if the landlord is allowing, that kind of act to happen, you can also bring a harassment case, right? Because they're not actually doing anything to stop the flooding as they should be, and it's making your life kind of unbearable in the apartment as well.
So I think the last question, and hopefully, folks should continue bringing the questions, but I do just want to flag that we're about to break out into groups where the three of us will be there and hopefully can ask and answer a couple more questions. But the last one is just a question about what happens if if the tenant is paying their rent timely, but the landlord is still sending you receipts that are asking for late fees, right? Which is a form of harassment.
Yeah. It's definitely a form of harassment. Late fees are generally governed by your lease, right? That'll say whether a landlord can or cannot charge late fees. But when you are paying your rent on time and they're charging you these late fees, it is a form of harassment. It's also thankfully late fees aren't something they can recover in housing court. It's nothing that they can evict anybody for. But it's just, again, another way to disturb tenants and make them feel like, they're not paying their rent or, kind of setting up maybe a case against them, something like that. But late fees, they're not something that can get someone evicted. They can't be recovered in housing court. And it's just another form of harassment.
We're moving on. I hope that you all had helpful breakout sessions talking about HP cases. We kind of wanted to transition from talking about HPs to talking about something that's, I guess, kind of like a super HP, something that's called a 7A proceeding. And it's called a 7A proceeding because of it comes from RPAPL section 7A. So just like a lot of other things, they have a terribly named statute for us to have to explain to people. So what is it? So back in the 70s, during a period of austerity where the city started seeing a large number of buildings that were in disrepair with landlords who were abandoning them, and then narratives that were blaming that abandonment on the tenants, the state legislature passed a law that allowed tenants to actually take some measure of control of the building back from the landlord. It's not that they become the owners of the building. It's not that they take full control. In a 7A proceeding, you can go to the housing court and remove a landlord from control of the building to the point where they're not even allowed to step foot in the building. They're not allowed to collect rent, and appoint an administrator to manage the property instead. And that administrator's primary task then is going to be restoring all the services and doing all the repairs that the last landlord didn't do. So, the question is, who are 7A administrators? They The Department of Housing Preservation and Development, or HPD, the city agency that's in charge of going out and placing violations when you call 311, also have a number of different enforcement arms, and one of them is actually running the 7A program. So they create a list of building managers who a judge can appoint to run your building if you win a 7A case. And they can honestly be all over the place. Some of them are nonprofits that are established as part of the housing movement in New York City. Others are private building managers who I frankly don't know how they managed to get themselves on the list. And at times, when a judge has moved to appoint a specific person off that list, we've had to go and find cases implicating those administrators in fraud to get them kicked out so that we can get a better administrator in charge of the building. Whether or not somebody is a good administrator or a bad administrator, one thing that tenants have to be prepared for going into bringing a 7A case to remove their landlord from control is that once the 7A is put in charge of the building, the only money that a 7A administrator is going to have to make repairs is what's coming in from the rents. So if you've got a building where everything's been so bad, where people haven't been paying the rent for a while, or even just the rents are relatively low, there can still be a lot of frustration, because if you have 20 units and everyone's paying $1,000 a month in rent and there's $100,000 worth of damage to do, that's still just $20,000 a month to put into the repairs. So it's important to, even at the outset of bringing a 7A case, it's important to set expectations. And despite everything I just said, there are a lot of good reasons to bring them. Like a 7A case is for the landlords who are the worst in the city. What the statute was designed to do was focus on buildings where there are conditions that are dangerous to the health, life, and safety of tenants that have existed for at least 5 days. And then also, it's been expanded to include, beyond shut-off of essential services, harassment and illegal eviction, which is why we're talking about it in this presentation. Also, if buildings are in the alternative enforcement program, this is a program for buildings that have the highest number of violations in the city, who are given basically a probation period to get their act together or else get slammed with tons of violations. All of that can be a basis to put a building into the 7A program. It's also important to know that just like HPs, tenants can file for a 7A case, or HPD, the city agency, can initiate a 7A program or 7A proceeding on their own. So when you're thinking about filing harassment claims, if there's really egregious harassment in a building, you might consider filing it as a 7A case instead of an HP. The trickiest thing about bringing an HP case is that to maintain it, you need 1/3 of the tenants living in the building to participate for the entire length of the case. So if you've got a 30-unit building and 10 tenants sign up for it, for the 7A case, at the time that you file, at that point, you're good. But if the landlord evicts somebody, gets somebody to drop out of the case, continues to harass them or do any of the things that were the reason why you brought the case to begin with, and the number of the tenants on the case dip below that 10, then your 7A is going to automatically become an HP, and you can still try and get a harassment finding. You can still try and get an order for repairs, but you're no longer going to be able to get the landlord removed and the 7A administrator put in their place. So a 7A case, like I said in my breakout group, that a group HP case is a good supplement to an effective organizing campaign where you've got a group of tenants who have a set of goals that aren't defined by the law, but are actually defined by what changes they want to see in the conditions that they're living in and the conditions in their relationship with their landlord. And the HP is one tool, one mechanism to get there. You have to think the same way of a 7A proceeding. It can be a short-term goal to get a 7A administrator placed in your building, but if that's all you're organizing towards, if that's all you're litigating towards, then you're setting people up for disappointment as well. It's about a longer-term organizing strategy to fundamentally shift the ownership structures in the building and the relationship between the tenants and the landlord. And that's kind of the last piece that there's not a slide for, but is important to know. If you win a 7A case, if you establish that there was harassment, if you establish that there are these conditions dangerous to health and life and safety that have existed for 5 days, and a 7A administrator is put in place, you suddenly have a landlord who is not allowed in their building, is not allowed to collect rents, but still has to pay off their loan to the bank. So they're hemorrhaging money. And now their incentives are going to be to either do everything they can to get the 7A removed, which is hard, or to dump their building as fast as possible. And that can mean either it's a great opportunity for a nonprofit preservation purchaser to come in and make that building permanently affordable, or it can mean it's a great opportunity for vultures to start circling and try and pick off this building at a discount price. So if you're getting into a 7A, you're also going to be thinking about having to fight off these potential bad purchasers in order to get the type of ownership structure that you ultimately want at the end. So if you're doing a 7A, you're looking at a possibly multi-year commitment to that building. And I would encourage anyone who's thinking about doing these cases to go in basically thinking it like you're going to be the shadow manager for that property for the next 2 to 3 years of your life. Questions?
So yes, so one of the first ones was how often are buildings taken away from landlords, if we know?
I don't have any stats on it. I think there was one 7A appointed last year in the Bronx from a tenant-initiated case.
Okay. The next question is a little bit longer. It says, is there a way to get a 7A action without a third of the tenants now that many are out of town due to COVID? This person's building has 18 units and a high number of violations. The landlord has been on the public advocate's worst in city list repeatedly, and the violations include several immediately hazardous conditions.
That's a great question. So the statute talks about the number of tenants who are in occupancy. So if a unit is vacant, but they haven't actually moved out permanently, I think that you're going to have some motion practice on your hands about whether or not you should be including the tenants who still retain rights to the unit but aren't living there. In a building that I worked in, people hadn't moved out because of COVID. There had been a fire in the building and there were vacate orders on 2 units. And the judge counted it as those units would not count towards the overall count for the 1/3 because they were vacant, even though there were tenants that retained their right to return to those units once they were fixed. But I think you could expect that if a intelligent landlord's counsel would try and raise that argument at least.
Yes. The next question is, what are the chances of a tenant winning this petition? This person says that they have done a lot of HP actions in court and 98% of them get rejected. And they have legitimate reasons or conditions to do an HP action. I'm not sure I understand that question. I guess, what are the chances of somebody winning a 7A?
So a 7A, no one's going to settle for agreeing to have a 7A put in charge of the building. whereas HPs oftentimes resolve in settlement. So if you're not able to push an HP to a point where a judge is going to even hear it, let alone make a decision, it seems extremely unlikely to me that you could get a 7A administrator appointed.
Let's see. People acknowledging that it's hard to get resources together and convince neighbors. If a landlord succeeds in removing one of the petitioners via eviction, meaning in the 7A, can you ask the 7A judge to adjourn while you seek to show that the eviction was an intentional harassment action designed to reduce the number of tenants participating?
Yeah, I think that would be the move. I think there are a lot of questions if you're filing a post-evict at that point of whether or not that person was unlawfully somehow removed. But if you have a tenant who the landlord targeted because they were participating in the 7A proceeding, but they actually were behind on rent or in violation of the lease, there was actual a legal basis for removing them from their unit, then I think you're going to be hard pressed to win that argument, which is all to say, and something I didn't add, is that you're going to want to screen everyone before you file these to see, not to tell them not necessarily to participate, but to know exactly what their vulnerabilities are, whether it's they're really behind on rent, whether they have somebody living in their unit that somehow it's a violation of the lease or the rent stabilization law, and to advise them accordingly whether or not they're putting themselves at risk, and hopefully being able to show up for them and tell them the ways that you can prepare to protect them going in. Because you definitely never want to know or find out these things halfway into the case when the landlord starts retaliating against them. You want to figure this all out up front. It's also a good way when you do that to figure out things that people are scared of impacting their involvement that maybe aren't as big of a deal as they think. It comes up a lot with folks who are undocumented. It comes up with folks who aren't undocumented, who think that maybe getting involved in this case will implicate their ability to apply for papers, which it wouldn't. And it comes up with folks who sometimes think that they're violating their lease when they're not. Like they have somebody who's living with them as a guest and it's allowed under rent stabilization law, but they think that that person is there without permission.
Okay. I don't see any other questions, but there are some comments in the chat of folks that have been either successful in bringing 7As or just sharing experiences. So thank you for doing that.
Oh, sorry. Okay, gonna kick it over to Cathy for the counterclaims.
Yay. Okay. Cool. All right. So I know it's a mixed crowd, so I will try not to bore too much with some of the details, but just wanted to speak briefly about how we can and should be using and raising harassment in eviction proceedings. So for defenses, you can raise harassment as a defense in a non-payment case specifically, especially when paired with a breach of warranty of habitability defense, meaning if the landlord has repeatedly failed to make repairs, and that is a reason either that the tenant is withholding rent or there's just been a case, sorry, that's my dog. I don't know if you can hear that. It's really weird. If there is a non-payment case that is brought against the tenant and there are bad conditions in the apartment or in the building, and so you're raising the violation of the warranty of habitability as a defense, you can and should definitely be coupling that with harassment, both as a defense and as a counterclaim. I know in the private rooms, we talked a little bit about how judges are very hesitant to make harassment findings against landlords, which the same, I believe, holds true in eviction proceedings, but that shouldn't discourage you from raising these things. I think one of my #1 tips always is to kind of be aggressive, right? Landlords are aggressive when they bring cases against tenants, always. And they have very aggressive attorneys. And in fact, I don't even know that I would call them aggressive, other than maybe just really dumb and really very bullying. Whereas I think aggressive can actually just mean being a smart litigator and advocate. So definitely try to bring these in your non-payment cases. And when it comes to holdover cases, you can also counterclaim with harassment. And that can look like, you know, maybe you have a rent stabilized tenant who absolutely has their name on a rent stabilized lease, but for whatever reason is being sued in a licensee holdover. I've seen that plenty of times, and it is absolutely a form of harassment, right? Because the tenant has a legal right to be there, but yet is being sued in this bogus case. And so it's really, really important that we push judges to make a finding of harassment, and to point out that if you're raising harassment as a defense or a counterclaim, specifically a counterclaim, that can give you some leverage in the case too, right? In an eviction proceeding, because landlords absolutely do not want to have findings of harassment against them made by a court. And so it gives your client a little bit of leverage when doing any type of negotiation. So that's always a good thing. Another tip is to make sure that if you are getting your case sort of kicked out for procedural defects or for another defense that you've raised on a motion to dismiss or a summary judgment motion, that if you have those counterclaims, specifically for harassment, that you ask for a hearing, right? A lot of times judges want to dismiss the whole case, and they'll do what's called severing your counterclaims, meaning that they are telling you should just bring it in another case, or you should file an HP. And you don't actually have to do that. You can push back and actually ask the judge to schedule a hearing. Some judges are a little bit better about that than others. I have seen some judges that recently joined the bench from the tenant side that will dismiss a case that the landlord brought and set a hearing for the counterclaims, which is great. I think if they can do that, all the judges can do it, and we should be pushing for it. So those are kind of just some of those tips. I think also, if you are bringing harassment as a counterclaim, then that gives your client a little bit more leverage at trial too, right? Because you're going to have the opportunity to really put on your case after the landlord puts on theirs, which is nice. And it's a nice way to kind of shift the narrative of the case, being only about somebody either not paying rent or some other dumb thing that the landlord is claiming. And so, yeah, please bring these cases. If you need samples or things like that, I think we will try to put them in the drive. If not, you should feel free to contact us. That's it.
Do folks have any questions? It doesn't seem like there's any questions, so we can move on.
I know it's like Friday and it's late and we're boxes, so you know. Yay.
Yeah. Thanks for your patience up until this point. So these last 4 segments, though it seems like we're only 2/3 of the way through on paper, the next 4 are going to be relatively short for those of you who are really looking forward to enjoying this muggy weather today. So we're going to go into construction as harassment. So I'm going to make all these things small. So construction as harassment is a phenomena that hopefully with changes in the rent stabilization law from passage of the HSTPA in June 2019 is going to change. So what we were seeing for years, especially in rapidly gentrifying neighborhoods, was that owners were purchasing, investors, predatory landlords were purchasing properties where you had long-term rent stabilized tenants who were renting at a rate that was below the market. And instead of just offering buyouts or doing the more traditional forms of harassment, the landlord started trying to actually make the person feel so unsafe in their home that they would leave or have to be relocated and then not be able to come back for sometimes years. And the incentive for the landlord to do that is that, one, just if you get somebody out, then maybe eventually you can get them to get tired and they start their own life somewhere else and they move on. But also when you get folks out, it means that it used to mean that you could make individual apartment improvements to the inside of the apartment such to the point where you could get the rent up to above $2,744 and actually make the unit no longer rent stabilized. So in those gentrifying neighborhoods in East Village, in Lower East Side, in Bushwick, in Williamsburg, landlords were really actively trying to aggressively push out tenants so that they could take a unit that was renting at $1,200 a month or $1,300 a month, flip it over, and suddenly start renting it out to young gentrifiers. Those laws all changed in June. There's no longer an amount of rent that somebody would pay that would make their unit no longer rent stabilized. There's also serious caps on those individual apartment improvements or renovations to the point where basically you're looking at an $80 increase in rents. And that is going to substantially change the incentives for landlords to do this type of harassment, but it's still happening. And there are also landlords that just don't care about the law and are hoping that it's going to change, and they're always on the offensive. So these are some tools to deal with it. So what does it look like? It looks like construction as harassment looks like unsafe work. So you've got guys that are running around with blow torches in a hallway without proper protective agreement. It means that they haven't secured the proper permits from the Department of Buildings and are doing work with possibly unlicensed contractors. They're doing work that involves the structure of the building, and they're not doing it in a safe and approved way. It means it can look like them not having a tenant protection plan. The Stanford Tenant Safety Coalition had a suite of bills passed 2 years ago, all focused on construction as harassment. And now when certain construction projects are being done in buildings, the landlord has to file a plan with the Department of Buildings explaining how they're going to preserve the safety of tenants in the property and actually post a copy of that plan in the unit or in the building. Sometimes it looked like the landlords like punching a hole through the wall of one apartment that they were working in and punching it all the way through to the apartment of somebody else. It's looked like taking axes to the boilers or just removing water heaters from buildings. So people have not only don't have heat or hot water, but have no way to get heat or hot water. Not having somebody on site who's required by law to be managing safety. Sometimes doing work that actually gets HPD or the Department of Buildings to be implicated in the harassment by destabilizing a staircase or a wall in a unit so that they actually, to preserve folks' safety, have to vacate them from the building. And then also part of the Stanford Tenant Safety set of laws was a Safe Construction Bill of Rights, where really on every floor of a building where construction is happening, the landlord is required to post something explaining all the rights that we're going over now. So if you're seeing this, one, you can raise these in an HP case like we were, or a 7A like we were already talking about, but frequently there's something really dangerous happening that needs to be addressed right away. Part of the Stanford Tenant Safety suite of bills was something called a real-time enforcement, where Department of Buildings is supposed to send inspectors out if you're reporting construction as harassment within 12 hours. Even 12 hours isn't fast enough sometimes if somebody's working in the middle of the day and they leave by the time the work is done. Or sorry, the inspectors get there after that person has left for the day. But it's still, if you see anything that seems like unpermitted work, anything that seems like dangerous work, you want to call 311, and it's still a work in process, but they have seemed to have trained their operators to hear the words construction as harassment and flag that. and then they send the complaint to the Department of Buildings, they don't necessarily intuitively know that if you call and you say there's loud banging coming from next door, or they put an axe through the wall and they punctured a pipe and now I've got a serious leak, the 311 folks might actually refer that to HPD for them to go and place a violation for a leak. And stupidly, but this is how it works, the Department of Buildings and Department of Housing Preservation and Development do not communicate with each other. So if this is something that's coming up in buildings that you're working in, you want tenants to know that the magic words are construction as harassment when they're calling 311. If you're having trouble getting these violations placed, the Stanford Tenant Safety Bills also created something called the Office of the Tenant Advocate. Right now, the Tenant Advocate is someone named Sarah Desmond, who is really responsive by email and by phone. And if you're seeing harassment happening, or you're having really any issues with Department of Buildings, even beyond construction as harassment, you can reach out to this office, and they're supposed to be a liaison between the tenant movement and Department of Buildings, who is frequently not super happy to have tenant advocates in their faces about things. So do you have any questions? Okay. Then I guess we're going to go on to the certificate of no harassment.
All right. Oh, hey everybody, that's me. The certificate of no harassment program is a new program, relatively new. It was started in 2018. So it requires owners of certain buildings to obtain a certificate of no harassment before acquiring a permit from the Department of Buildings or DOB for work involving demolition or change in use and occupancy of the building or the apartment. A certificate of no harassment is only granted if HPD finds that the landlord didn't engage in any harassment. If the CONH is denied, then the landlord cannot obtain permits to materially alter or demolish the building for a period of years. And so there's certain buildings that qualify, and we'll get to that now. Greg. So basically buildings that became part of this pilot program. So it's a pilot program, so it's new and it only includes a certain number of buildings. The link for the Google Drive that we have has the list of buildings that are part of this program. So you can take a look at it to see if your building or building that you work with is part of this program. But buildings with high levels of physical distress or ownership, or a lot of ownership changes in certain targeted areas of the city, were placed on the building list. Also on the list were buildings with a full vacate order, were active participants in the alternative enforcement program for more than 4 months since February 1st, 2016, and buildings where there have been findings of harassment within the last 5 years by a court or by DHCR. And so there is a process for how this all works out. So a landlord that's a landlord of a building that's part of the pilot program has to apply for a certificate of no harassment. And then the tenants, community groups, and community board and elected officials will be notified of the application. And so HPD will collect comments from tenants, current and former tenants, to determine whether harassment occurred in the building. If HPD finds that there was harassment, a case will be brought at the Office of Administrative Trials and Hearings, or OATH, for finding of fact and a recommendation as to whether harassment occurs. So there will be a hearing, right? So if HPD investigates during this time and they find that there's reasonable cause to take this to a hearing, there will be a hearing. In that hearing, the landlord, so the tenants can testify as to the harassment they face, and then the landlord will also have an opportunity to defend themselves against whatever instances of harassment that the tenants are alleging happened. And then oath will make a recommendation to the commissioner of HPD whether to issue a certificate of no harassment. And then that, if the CONH is denied, then it prevents the landlord from obtaining any permits to materially alter the building for a period of years, depending on the law or depending on the program itself. And the owner may be required to construct certain percentage of low-income housing units to address the harassment finding, if there is one. So this is certificates of no harassment are good tools against landlords getting MCIs before the HSTPA passed in last year, because landlords will use MCIs, these great big, we're going to talk about MCIs later on a bit more, but MCIs are major capital improvements. So these are huge improvements to buildings that didn't need them to raise rents and to push units out of stabilization and to push long-term tenants out of apartments. So the certificate of no harassment is good to prevent these MCIs and prevent landlords from pushing out long-term rent stabilized tenants. So, oh, sorry. And that's it. And there's questions.
Yes, there are questions. So the first is, why would a landlord apply for a certificate of no harassment if that would be against them?
So if they're one of the buildings required to apply for one, then they have to, right? They have to apply for a certificate of no harassment in order to make any major improvements to a building, to do any big demolition work to the building or materially alter it. And if they don't get that, if they are denied the certificate of no harassment, then they can't move forward with any of that material construction or changes to the building.
There's another question that says, how do you get the landlord into the certificate of no harassment requirement or program if they keep defaulting on their oath hearings and just paying fines without correcting things or getting proper permits? It seems like HPD and DOB separation is an issue here.
So the buildings are put into the CONH project, right? These are buildings that were chosen by the city. There's by the criteria that I just stated. So there are buildings in distress that are in need of repairs, have gotten a lot of, there's been a lot of change in ownership in them, are in neighborhoods that are being targeted by like gentrification and things like that. So the city determined what buildings are in the pilot program for now and have to get certificates of no harassment to do any construction or material alteration to the building. And I feel like that's more of a comment, obviously, than a question. They keep defaulting on their oath hearings and just paying fines without correcting things. Or I fail to see the connection with the CONH. But yeah, again, like not the most perfect tool, but it is a tool to use to kind of stop MCIs and these big increases in rent. I mean, now obviously not such a big issue post HSTPA, but it was. So the buildings are already part of the pilot program. I think once this is like the first rollout, I think they'll do the same thing again and include more buildings within the program if the city finds that this program is helpful for tenants in these kinds of buildings and decreases the amount of harassment.
So there's a comment and then a clarifying question. The first is to clarify the previous question is maybe how do you get your building on the city's list for inclusion in the pilot program if there is a way?
Right, like I said, these buildings were picked by the city. So like this is the first round of buildings that are part of this program. I don't know for sure if there's a way to get your building into it if it's already not. But if this program, is successful, right, they might be included in the next round.
And there's a suggestion from someone in the chat that says one way could potentially be by getting them into the AEP program, which is what Greg talked about earlier, the alternative enforcement program, by calling 311 and 10 and trying to get as many violations as you can.
Right, because again, one of the criteria is buildings that are in distress. So a lot of conditions is, would show that.
And there's a comment from another person that says that they have a case where the landlord was coached by DHCR to apply for sub-rehabilitation exemption. And the investigation by HPD actually missed the nuances, which is pretty unusual, and asking to maybe talk later.
Okay.
Flagging that for later.
Cool.
I think that's probably about it. So yes, we will give our contact info, or have different folks volunteer it later. But cool.
Yeah.
I think we're up for DHCR and fighting MCIs.
Yeah, so we're closing in, folks. We are getting there. So we spent all this time talking about things you could do in housing court, all the ways that the state harassment law in the early 2000s was trash, and why New York City Council had to pass their own harassment law. And now we're going back to why you still might actually want to use that state harassment law instead of going through the rigmarole of housing court. So this section is talking about raising harassment claims at DHCR and how that can impact MCI, or major capital improvement applications being made by landlords. So some folks know this in their soul, and some folks, this will be the first time they've heard of DHCR. DHCR is the Division of Housing and Community Renewal. It's the state agency that's in charge of dealing with all of the rent regulation laws in New York State. So when you send a tenant to find out what their rent history is for the rent stabilized unit, that's DHCR. When you're filing a reduction of services complaint for bad janitorial services in your building, that's DHCR. And then when your landlord wants to increase the rents on a rent stabilized unit, whether that is filing for a major capital improvement for having made a repair or really renovation that they claim accrues to the benefit of everyone that lives in the building, they have to do that at DHCR. It's an administrative agency that most of their decisions are made outside of the courts. Most of the time you are filing papers and getting papers back from them. You're not going to a hearing in front of a judge. It's really important, though, that to acknowledge the limitation of DHCR. They only have jurisdiction over rent stabilized and rent controlled units. So if you are working in Ridgewood or Bushwick or parts of Flatbush, where a lot of the tenants are market rate tenants in buildings that have 6 or less units, you're not going to be able to go to DHCR to assert these kind of harassment claims. Going backwards there, sorry. So the definition, Cathy sent out at the very beginning a link of the Housing Maintenance Code definition of harassment, but by now has subparts A through G and has all these specifics of what constitutes harassment, from like the most obvious aggressive threats to condition-based issues to buyouts. The state harassment law hasn't changed very much. I've just put it up on the board here to see what it is you need to prove. And it's pretty broad compared to that statute. It's any act which interferes with or disturbs or is intended to interfere with or disturb the privacy, comfort, peace, repose, or quiet enjoyment of the tenant. Sometimes it's to vacate. Most of the time when we're talking about harassment, it's just to try and force a tenant to waive or not exercise any rights afforded under the Rent Stabilization Code, which could mean anything from trying to challenge a major capital improvement application to filing a reduction in services at DHCR to having a roommate that is allowed under the code but not under their lease. And then it has like a really small subset of specific examples of what constitutes harassment. So interruption or discontinuance of required services, unwarranted or baseless court proceedings, frivolous eviction cases, or filing of false documents with or making false statements to DHCR. And I want you to keep in mind the filing of false documents with or making false statements to DHCR as we're going through this. So in your breakouts, you might have talked about what it's like to file a pro se case in housing court, where you show up to an HP part where there are 30 other people who have conditions cases that are on. Particularly a pro se tenant is going up in front of the judge who has very limited time. And even if they can convince that judge after 2 or 3 adjournments to actually have a hearing on the harassment, that judge might have 30 minutes to 2 hours spaced out every month to hear testimony on that case. It can be disheartening, it can be exhausting, and it oftentimes isn't effective, especially if somebody is pro se. DHCR has kind of a mediation process that is built into their harassment filings that sometimes for tenants who are looking not necessarily to leverage a harassment claim as part of a broader organizing strategy, but is actually looking for a way out of a problem, might be more effective. So initially, to start it off, it's pretty easy. There's a 4-page complaint that DHCR has that you'll find included in that Google Drive that I mentioned earlier, next to their fact sheet for filing these harassment claims. But it's something where a tenant can really write a paragraph saying, this is what happened with my landlord, and mail it into DHCR. When DHCR gets that, they're going to mail a copy to the landlord and invite the landlord and the tenant to come to a conference with one of DHCR's attorneys, where the attorney is simultaneously going to kind of try to investigate, ask the tenant questions, see what it is that happened and whether or not they think that it's likely that there was some kind of harassment, and push the parties into some kind of agreement to assure that the harassment doesn't happen going forward. That agreement, depending on what it is, like I've heard of instances where they've just said, like, you know, you have to reach out by text about arranging access dates rather than showing up at somebody's door whenever you want, to no, landlord, you're really not allowed to go into the kitchen and just start ripping out the cabinets so that you can get an MCI for cabinets, which you're not allowed to do anymore because of HSTPA anyway. And if that agreement doesn't work, the tenant can send the case back to DHCR's enforcement unit, who will then act like the prosecuting arm of DHCR, and their attorneys are going to bring the landlord to a formal hearing in front of an administrative law judge within DHCR. So it's a little bit weird because then it's not the tenant's attorneys who are doing it, but actually the attorneys from DHCR that are pushing the claim. The other reason why you might want to bring a harassment case in DHCR is what I mentioned or highlighted earlier about this filing of false documents. That's not something that's under the definition of harassment in the Housing Maintenance Code, though maybe you can put it under that subsection G, that's the catch-all provision, but those documents aren't getting filed with it. DHCR actually has jurisdiction over false documents that are getting filed with them. So why would you want to push like your landlord over the false filing of these documents? Even though major capital improvements have been curtailed by the HSTPA, they can still be used by landlords to jack up tenants' rents. So when we're fighting an MCI as a building, now one of the new provisions that's been expanded is that if there are Class C and B violations in the building, the landlord can't take the MCI. And what I find, unfortunately, especially in buildings where people's first language isn't English, is the landlord will go around with a super or with workers doing some repairs, saying that they'll come back and do the others later, or saying that the workers are not going to get paid unless they sign off on a sheet of paper. And that piece of paper confirms and certifies that all of the work in their unit is done and all the violations have been lifted. And then the landlord submits that documentation to DHCR. That's harassment under the statute. So if you can show that a landlord is fabricating documentation that they're submitting in the course of one of these applications, not only can you fight the application, you can get a finding of harassment. And if you get a finding of harassment, no rent can be raised. So rent reduction orders, renewal leases, no rent can be raised until that harassment order is lifted. They can't get any MCIs. And if there's harassment that was done in the course of actually doing the work for the MCI, that can be a basis for knocking it out. And then you have these other penalties that most tenants are not particularly interested in and aren't great leverage because they go to the state. So DHCR can get $3,000 for the first offense of harassment and then up to $11,000 for additional offenses. But this is something that we use, or I use, more so to either like help deal with a tough situation with an interpersonal issue between tenant and landlord, or in the context of these like administrative battles over MCIs or over building-wide rent reductions. Okay, that was a lot. Are there any questions?
Seems like there's a long question that's generally about HPs. Okay, so the first one is, if someone previously settled an eviction case, most likely a holdover agreeing to vacate, can they subsequently bring an HP for harassment after they settled but before they vacate?
It may depend on the terms of, I mean, it's definitely going to depend on the terms of that settlement agreement about what claims were waived or raised.
Mm-hmm.
That's, I mean, if they're in possession, I think you can still bring a harassment case. The question that I have is, I don't think that the harassment case is necessarily going to get you the right to stay in your apartment. So if that's your end goal,
Right.
You might be wondering whether or not there's a argument you can make to vacate the judgment or the agreement that you made because of the context in which it was made.
There's a question related to DHCR, which is, if you know, who facilitates the DHCR landlord-tenant conference for harassment cases?
It's attorneys from their enforcement unit. So it can be, I don't do this often enough to like know the individual personalities of them the way that I would for the HPD attorneys. So I can only say that I imagine that it varies a lot depending on who you get. But if anyone has experience with that, who can speak in more substance, it would be great if you could put that in the chat so folks know that they can reach out to you as a resource.
I think that's it for questions on this section.
Cool.
Yay.
Well, then we're going on to our last section, folks. We're in the home stretch.
Oh, yes.
42 minutes before. Oh.
Someone's just clarifying, which you're absolutely right, is that even occupants can file complaints about HPs. So clarifying point. Thank you. Cool. Thanks for using the chat, everybody. This is helpful.
So the last part of this is about the actual criminal laws dealing with harassment. I want to preface this by saying I have no experience practicing criminal law, and the only context in which I've dealt with this is talking people through their options and attempting to make referrals to district attorney's offices, which is frequently not gone over so great. So I think the first question before getting into the meat of the law is like, why or when would you want to do this? It is not uncommon that we'll go to a building and have initial tenant association meetings where like the conception of what is just or what can be like, what would be punishment or an end goal is getting the landlord put in jail for something that they have done wrong. And I think a lot of the work of organizers, especially at the beginning, is helping people start thinking about what their relationship is with their landlord and what they want it to look like. And sometimes them going to jail, or more likely, even if you get to that point, somebody who works for them going to jail might not actually fundamentally change that relationship in the way that some other organizing goals might. But it's still, I think, important to go through what the pros and the cons are of getting a district attorney's office or the police involved, or possibly the attorney general's office if they choose to pursue criminal charges. Some reasons that you might not want to do this is that cops and district attorneys go after the lowest person on the ladder and then try to roll them up onto the next person, which means that at least initially the person who's getting the knock on the door and oftentimes is the person who did the harassing act is a construction worker, a superintendent, or somebody who is probably getting paid very little money and did something bad, but is not the person who's actually benefiting financially from all of the crappiness that this landlord is engaged in. And maybe they get rolled up, maybe they don't. So like, is your goal to see same conversation you might have about whether or not people's goal is to get a super fired. Like, is that going to actually resolve the underlying issue in your building? Another thing that gets frustrating when you're involved in a criminal investigation is district attorney's offices, the attorney general's office, they're not going to, it's a black box of information. They're only going to share with you what they feel that they're able to, and that's going to be based on your personal relationships with them. So you could be sending them a ton of information and not hear back anything for weeks, for months, sometimes for years. And it's very weird to put tenants' hope in this entity that is non-responsive and not accountable. And it really kind of takes that power out of the tenant's hands and put them into this like black box. That also means that you don't have negotiating power that's coming out of this. Attorneys can't ethically leverage the threat of criminal reporting somebody or somebody getting convicted of crimes in the context of civil cases. It's explicitly barred by attorney ethics rules. So while you might want to get the district attorney or AG's office involved with a case, like you can't be saying like, we're not going to report you unless you do XYZ for the tenants. Like that's a nice way to get a bar complaint filed against you. And then like, I'll just throw in like, and maybe I led with it too, so I'll just sandwiches it. Like, what are you getting out of making the point of your campaign, send this person to jail? Like, we've seen it. We saw Steve Croman go to jail for a year. He's out. He still has as much money as he used to. But that is like a much broader kind of ideological conversation about when you're using criminal laws to occasionally get like the big name bad apples with a lot of money. How many other people are going into the system who don't have any kind of financial power like that? Based on that, my office generally doesn't support the passage of or the expansion of laws that increase criminal penalties for landlords. But there are some pros of going to these agencies. So one is just like, we like to talk about mediation. We like to talk about community alternatives to dealing with crises and violence, but they don't all exist. And sometimes if somebody's in immediate danger, contacting the police is the most immediate way to actually prevent something bad from happening to somebody, and that's real. It's also real that like jail time and like the threat of going to jail used by the district attorney or the AG's office can force the landlord into doing things that they otherwise never would have. The odds that the tenants are going to be at the table for those conversations is very low. But if your job is to just see this person punished, like they're not going to be happy sitting in a cell if that actually happens. And then third is that there are certain acts, criminal acts committed against undocumented folks, which can actually result in them getting status if they in some way aid the district attorney's office in pressing charges against the landlord or their agents. In these cases, they can get something called a U certification, which can be used to get a U visa. There's a lot of complexities around that, including the fact that there's a limited number of U visas that can go out every year, and there's a massive backlog. It's also important to know that it's not just district attorney's offices or cops that can give you U certifications. Agencies like the Commission on Human Rights can also certify somebody. So if that is your end goal, you can also be exploring, like, can I file a discrimination claim on behalf of this tenant rather than calling the cops? Because also the people who work at the commission used to work probably at some of our agencies too, and they might be a little bit more friendly in getting that U cert at the end of the day. But let me get into the substance of the actual harassment crimes. So there are 4 harassment crimes that don't say anything about tenants. This is just what the law is on the books for harassment between any 2 individuals. So I have to move this. So harassment in the 2nd degree looks like somebody, you need to have this intent element. That's always something in criminal law, like somebody had to want to cause, harass, annoy, or alarm you, and then they strike you, they follow you around, or they are constantly doing something that makes you feel alarmed or seriously annoyed. So somebody asked earlier in a breakout about getting constant text messages from a landlord. Like, you might be asking, or this harassment statute could apply just as easily to an ex-boyfriend. Like, you might want to be asking yourself, is the way that this person is contacting me actually rising to the level of criminal harassment? And the sentence for that would be it's a violation, so it's up to 15 days in prison. There's harassment in the 1st degree. Sorry, my screen share is all over the place. Which can result in up to 3 months of imprisonment or 1 year probation and a $500 fine. And then it gets more and more intense. So someone can get up to 1 year in jail or 3 years of probation by delivering a threat by phone, mail, email, or some other method to cause and as a threat to somebody's property or their person. So this is like old school harassment that is also defined under the Housing Maintenance Code. If someone's literally threatening you, saying, stop suing me, don't organize in your building, that could ratchet up to being a criminal offense that could get somebody put away in jail for a year. And then last, just because it's under the definition of harassment, is the most egregious form of harassment under the law involves what are typically called like hate crimes. So damaging houses of worship, displaying swastikas, nooses, burning crosses, that can get someone up to 4 years in prison. And I'm highlighting these sentences because I want you to look at what it is for a 4-year sentence in the context of a aggravated harassment in the 1st degree and what type of act that is before we go and look at the tenant harassment law that was included in the HSTPA last year. So the HSTPA has this both new definition of harassment and also expanding sentences, because now it can be considered a Class E felony. So if an owner is guilty of harassment of a rent-regulated tenant with the intent to cause the rent-regulated tenant to vacate housing, and they've caused physical injury or recklessly caused physical injury to such tenant or a third person, Now something that could have been anything from like a 15-year or 15-day sentence to a 1-year sentence, because it's involving tenants, is now giving you 4 years of imprisonment, which is the same number of years of prison that you would have gotten for burning a cross on somebody's lawn. So what does it look like practically to report this? A lot of cops and precincts are not going to know about the tenant harassment law specifically. Frequently when tenants in over and under policed neighborhoods are calling the police in our buildings to report harassment like this, the police show up and don't do very much. So an alternative is to go to the precinct and file a police report to keep some kind of track record. If someone's getting a lot of threatening text messages, threatening phone calls, they can bring in that evidence to the police report and sit down and take a report. If your organization has or wants to develop a relationship with a district attorney's office, there are individuals in each office. Actually, it varies on the office of how interested they are in hearing about these kinds of cases. Sometimes they have to see it in the press before they have any interest in actually pursuing it. I think here is where sometimes a relationship with your local elected officials can help leverage that if you want to try and get a investigation into a particular landlord for the acts that they're involved with. Other than that, I've not had very much experience or luck getting district attorneys' offices to investigate claims. The only time I did do that, we spent 6 hours going through a bunch of information with 4 of their attorneys, and then we never heard from them again.
Okay. There is one question that you may have answered, but just asking it one more time, is if you know what the right unit or subdivision is to contact at the DA's office specifically for harassment.
I do not.
I don't see any other questions, but if folks do have questions either about this section or generally, I know several folks have asked whether or not we will post this amazing Prezi publicly, and we will. Shout out to Greg for forcing us to use Prezi. And we will definitely put it in the shared drive. Yeah, do folks have any other questions?
Yes, I have a question.
Yeah, please.
What if a landlord sue you for non-primary resident, which is a frivolous lawsuit, and then followed by construction as harassment? This is Steve Croman doing it.
Are you asking what your legal options are, or?
Is this, what kind of harassment is this considered as? And how do you look at a situation like this?
So I think any lawyer that's working with you would have to get into, or with that person would have to look into the very specifics of the case. It can be very hard, or sometimes it can be hard to establish that there's strict, frivolous actions in terms of bringing a eviction case on some types of holdovers if the landlord can establish that there's some factual basis for them thinking that they had a reason to bring that case. But sometimes it is absolutely totally frivolous.
What if lawyers are supposed to be helping you, but they are on Croman's side? They don't want to deal with the subject you are trying to tell them.
Oh, you always have the option to fire your lawyers and hire or find another counsel if you think that that lawyer is not properly representing you.
Thank you.